trouble with CCAP this morning?
Oh, I got in right away.
Can't get into cases, voting. Come on in. All we're doing is just this one motion all day, pretty much. So, nothing's happening. And I'm having trouble with CCAP. It's not working right. What's going on here? Can't get into the record. It's not available. Okay. That's not good. Maybe. Please. Can't get in. There we go. Oh, front door or something. Right at 8. Okay. 'Cause they were already in here. The reporters were in here before. I got it before.
Must have unlocked it like right after. So I just went up to grab 6 and then I was like, I never showed up. I was like, I'm just gonna go back.
There we go again. This thing is really slow today. This is the case. It's gonna take the affidavit possibility. A lot of motions. I tell you, there's too many files.
I got some ear things for you to try and help with hearing.
See if they work.
Exactly. There. You came prepared. Here's a better one. Favorite pencil.
Are we good?
I believe so.
All right. Let's go on the record. Mark D. Jensen, 2002 CF 314. Let's have the appearances, please.
The state appears by Carly McNeil from the Kenosha DA's office and Robert Jamboy, special prosecutor.
Attorneys Bridget Krause, Jeremy Perry, and Mackenzie Renner appear on behalf of Mr. Mark Jensen. Mr. Jensen appears in person in custody. Good morning, Judge.
Good morning. We have victim notification from the state.
We are in compliance.
All right. We are here for motions, and it's my understanding the defense has 17 motions. Am I right on the number? Or is it 16?
Judge, I don't have that many on my sheet. I know that there is a motion in limine that has multiple ones within it, but I have 11.
11? Good. That's a good start. We got rid of 6.
The question is what 6 we got rid of.
All right.
So,
Go ahead.
The state did count 17 defense motions, and those are numbered in the state's consolidated reply filed June 27th of 2022. So if it's not 17, then we're not sure what the number is.
All right. Well, I'm going to knock some of them off right away. Since the defense filed the motions, they should keep track of my rulings, and we're going to need some kind of written order to be filed, so then when we're in trial, we don't have any issues about evidence or rulings that are not being abided by. So the first one is the request not to use the word victim. I'm going to start out by saying that Wisconsin's always been giving victims rights. In 1993, we had a constitutional amendment, and it mentions victims numerous times. And now, as the attorneys are also aware of, we had Marcy's Law passed. That's still the law of the state of Wisconsin. It hasn't been overturned. And I believe when it was on the ballot, it was passed by 75% of the voters in Wisconsin. And Marcy's Law talks about, I think, at least 16 rights that victims have. And it mentions victims constantly. And there are enforceable rights through the criminal justice process, just like the accused person has. And one of the interesting aspects of Marcy's Law is if the judge doesn't follow Marcy's Law, he can have consequences. Not the attorneys, but the judge. So that's how strong victims' rights are in Wisconsin. And it talks about, and I think the exact wording on one of the sections talks about crimes committed by a defendant against a victim. It doesn't say convicted, it says committed. So I'm going to allow the use of victim. It's very, has a strong history in the state of Wisconsin, but we're not going to have a trial where we say victim 2,000 times. I think the state, they've have experience in numerous trials, and they understand what I'm saying. But it's going to be allowed. This is a homicide case. There's the burden of proof beyond a reasonable doubt. I think the jury will understand what their role is, that they have to look at the evidence and base their decision on the instructions I give as to jury instructions, as to what the burden of proof here and all the other instructions, and make their decision as to that. So the word victim's going to be allowed. The other motion that I'm going to decide, I think it's the only state's motion, and Ms. McNeil, you can correct me if I'm wrong, but you want the jury to be able to ask questions during the trial, correct?
So that was a response to a defense motion.
So who asked for that?
The defense referenced that in one of their motions in limine, and the state's response was, let's just follow the jury instruction on that.
All right. If you're going to talk for the defense, you got to obviously say which attorney's talking for the reporter, or the record's not going to be clear. So who wants to respond to whether I should allow the jury to ask questions?
Judge, I will. Bridget Krause for the defense. I'm asking the court not to allow the jurors to ask questions in this particular
That's my ruling. I think it's I don't want to say a disaster, but it creates a lot of issues. If they ask a question that's not allowable under the rules of evidence, not relevant, it's difficult for them to understand. They want to ask their question, and then they don't realize why they can't. And then, to be quite frank, sometimes it really destroys one party's defense or one party's prosecution. And they've worked so hard in their trial preparation, and suddenly this juror asks a question, and they go, wait a minute, we don't want you to go there. And the other thing is, I think the original Jensen trial, and Mr. Jambo, you can correct me if I'm wrong, was the longest jury criminal trial in the state of Wisconsin.
Well, I don't know about that. It was the longest.
But that's
one
what I
I've
heard.
done. And it may well have been. It was a total of 6.5, 7
And I
weeks.
think there's 125 witnesses. Am I right on that?
Yes.
Okay. This case is going to take a long time. And to ask jurors to sit for 4, 5, 6 weeks, I don't know how long, just with the witnesses that we have and just with the questions the attorneys are going to ask, and then we're going to throw in allowing the jury to ask questions, that's just going to make the trial longer. And I don't think it's going to get to the ultimate question, because I think the attorneys representing the state and the attorneys representing the defendant know what questions to ask, and they know what their defense is going to be or what the burden of proof is, and it'll come in. So we're not going to have any jury questions. Discovery issues. I'm shocked that we have a discovery motion. That's my start. It's a 2002 case. It's 20 years later. I was a defense attorney a long time ago. I've known that the Kenosha District Attorney's Office has an open policy. It's one of the best things they did for discovery. It's been there for years. This case is in front of a judge for the third time. What discovery does the defense not have? I want specific. I don't want just, we don't know. Tell me what you don't have.
So, Judge, just to be clear, just last week we received a witness statement and an investigator report from 2017. It's
All right.
the first time we had received it, so I appreciate that it was sent. But obviously there are some outgoing discovery issues. Specifically as it relates to the snitches in this particular case, I believe the response is that they didn't receive any additional consideration. But what we found is when Bernard Bush pled guilty, on the back of his guilty plea questionnaire, it says that the district attorney will mention his cooperation in the Mark Jensen case. We don't have any of that information.
Is he been sentenced already?
He had. That happened back in like 2008.
Okay. And did you look at the CCAP records to see what happened at sentencing?
We have the sentencing document. I mean, we can have the sentencing transcript, but the reality is we don't have whatever was promised to him at the time that he testified in this case, and not just him, Judge. We have another snitch in this case. What's his name? It's just left me. Yeah, Aaron Dillard, in which he testified in this case, and then there's a letter from the special prosecutor to the DA that is filed after the Jensen trial at the time of his sentencing. We don't have a copy of that.
So you want me to adjourn the trial date?
No, I just would like a copy of those.
All right. Can the state provide that information?
So, Judge, in our consolidated response filed in June.
You want to tell me what page that response, the page on it?
Yes. So let me get the page number for that.
Because I know it's 87 pages.
It is, because there's a variety of attachments. So this would be relating to defense motion number 12, which is referred to on page 21 of the state's response. And then that refers to attachment 8 of the state's response, and so I'll scroll down and get that page number.
Are you telling me that answers their question?
So we believe that it did, and we didn't receive any additional information after we responded in this way. So that would be page 71 of the state's consolidated response that has a letter from, at the time, DDA Angelina Gabrielle, and then letters that the state provided regarding these various witnesses.
All right, who wants to respond from the defense side?
So, Judge, we do have the letter, it looks like, from 2016 on Aaron Dillard.
66, but like 20.
I don't see anything on Bernard Bush.
Did you hear the statement as to Bernard Bush?
I did, and so if the defense can just specifically describe what they're looking for, then I can try to reply to that.
All right, why don't you do that for Ms. McNeil?
I'm looking for any promises that were given to Bernard Bush as a
At a
result of his
sentencing?
testimony.
All right. Did you hear the response?
I did.
Okay.
So I believe that the letter in the state's consolidated response answered that question, but I can follow up on that and.
Why don't you follow up on it? So the only issue left is Bernard Bush, and we can revisit it if it has not been accomplished.
And Judge, another thing that we're working on is the updated criminal convictions for all our witnesses, and so we'll certainly provide those to the defense. We plan to do that before our judicial pretrial date in December.
I mean, I've had trials where we would wait to see if the person's going to testify, and then before they get on the stand, we figure out how many prior convictions are, and then we, obviously the witnesses talked to and told them the number. So I mean, I don't think that's a big issue.
Agreed.
Okay. I don't know how to bring up this other motion, but is the defense still wanting Mr. Thompson to testify that he sold cocaine to Bob Jamboys in 2006 or 7 or whatever that year was during the trial?
Judge, this is Jeremy Perry for the defense. We don't believe that what Mr. Thompson is saying is true. Okay, we think that this is a lie of Mr. Thompson's. We do think that his lie about this and his claim to say, or his willingness to say whatever he wants to say to try to get him out of whatever situation he's in whatever moment he's in, we think that his lie is relevant in terms of being cross-examining him on that. And this is the state's witness. So he's
I don't care whose witness it is.
Well, it's the state's witness, and this is what the state's witness has told us has happened. And so it's,
Give me a date that he told you this, the exact date.
It's June of 2017. It says June of 2017. Let me see. Yeah,
11/2/2016.
When?
November 2nd, 2016.
That's when he told the investigator about this.
Yes.
And when supposedly did he sell the cocaine to what year?
It was sometime between November of 06 and January of 07.
Between 2006 and January of 07.
And where did he sell this cocaine to him?
We don't believe he did that, but.
On a roadway in Salem in Kenosha County at nighttime.
All right. I think I could take judicial notice that Mr. Jamboy was not the district attorney that year. And my understanding, he was working for the state of Wisconsin in Madison.
That is correct, Your Honor.
The governor had,
From October, I started that job October 1st of 2005
right.
and moved to Madison with my family.
So you're not in Salem?
No. About 2 hours from where I lived.
You know, credibility of witnesses is always an issue. We impeach them based on prior statements. We ask them about prior convictions, and if they give us the right number, we don't get into the conviction. There's also other issues. If somebody's been convicted of some crimes that deal with truth, fraud, we bring that in. But I'm shocked that the defense would ask for this.
And Judge, just to be clear.
Can I finish?
Oh, sorry, Judge.
I think it's Bush League. I think it's unprofessional. I think it's outrageous. I've been an attorney since 1983. I've been a defense attorney, an assistant corporation counsel, a municipal judge, a court commissioner, a guardian ad litem. I've never seen this. It's garbage. I'm not going to hold this ruling against Mr. Jensen. The record should be clear. But I think on a professional standpoint, it's uncalled for. And to say that it's a lie, what power do you have to tell me somebody's lying now? Do you have some magical power that somebody said something in 2016 about a drug deal in 2006 when Mr. Jamboy doesn't even live in that county? Well, one, maybe he's mistaken. And what is the jury going to think? What does this have to do with the guilt or innocence of the defendant? You're going to impeach Mr. Thompson. I think this is the, if I'm correct, because I did try to read everything, is the gentleman that was charged with 2 robberies in Illinois. Am I right?
Bank robberies, yes, Your Honor.
Bank robberies. So, I mean, how much? There's your impeachment. And Mr. Jamboy's did write a letter to the, I think it was the federal judge.
I wrote a letter to some judge.
Yeah, well, whatever. But, so we know that he got consideration for 2 bank robberies. I mean, that's pretty good impeachment. And then the prosecution fulfills their obligation. So now the defense wants me to allow this defendant to say, yeah, I sold cocaine to the prosecutor who was trying this case. I mean, if it was on the other foot and the prosecution wanted me to say, hey, one of the defense attorneys bought drugs from one of the witnesses, the defendant would be screaming. And if I allowed that in, I'm sure the Court of Appeals and the Supreme Court would say, what did you do, Judge? That is so damaging. No way. It's reckless. It's just not professional. It has nothing to do with this witness. It is so outlandish that it would just confuse the jury. It's not the way to defend the case. But again, the record should be clear. I'm just making a ruling on this motion. The other portion was, I did read that Mr. Thompson said that he sold the drugs for Mr. Brantley because Mr. Brantley couldn't do it or was in Chicago or whatever. There's documentation that Mr. Brantley was in custody at that time. So it's not coming in, and I'm not going to hold it against Mr. Jensen. He has an absolute right to a defense. And his public defenders can defend him with all sorts of other evidence and witnesses, but this is not coming in. There's no probative value here at all. It would confuse the jury to the utmost extremes. Okay.
Judge, I think we can get rid of number, I don't know what number it would be, the motion in limine that was filed by Stephen Glenn. My understanding is that was filed by Attorney Vishny because she was not prepared to file all of her motions, so she filed that. That's the purpose of that motion being filed. I think she then filed motions in lieu of that, so that could be withdrawn. I don't think we need to discuss that.
Which motion is that?
It was the motion that Attorney Glenn filed back.
What's the motion regarding?
Motion in limine miscellaneous.
All right.
It has a bunch of random things that were decided back in 2008.
I'll make a random ruling that we're not going to decide that.
Okay. We would just withdraw it, Judge. I think that
All right.
additional motions were filed in lieu of it.
Let me get here. Oh, the issue of hypothetical questions, is the defense still asking me to limit hypothetical questions?
Your Honor, this is Attorney Renner. Your Honor, we just want to make sure that hypothetical questions are limited in such a way that they can be understood by the jury. When we get into, 2-minute, 3-minute descriptions of a hypothetical question, that seems extremely long, confusing, and really should be done more in if you ask me, in a smaller chunk, so the jury is very clear on what the facts are that the expert will be relying upon.
I think, and again, Mr. Jambois, you can correct me if I'm wrong. I think in the original trial in front of Judge Schrader, I think he did not allow 2 hypothetical questions. That's how much I read the transcript. So there was 2 times, and I have great respect for Judge Schrader. I mean, the man knows the law. You might not like his rulings or his sentence or whatever, but you want a fair trial, you go in front of Judge Schrader. I don't care what side you're on. He's going to give you a fair trial. So hypothetical questions are allowed. They're used by experts in, one of the interesting jury instructions as to an expert, and I've read it so many times in civil cases, is the line the judge says to the jury, you are not bound by an expert's opinion. You don't have to listen to any expert. I mean, the only civil case where you need an expert is a medical malpractice case. That's the only one. All the other civil cases, you don't need experts, and the jury doesn't have to listen to them. And that's how experts testify. They get hypothetical facts. And again, even some of the facts that are given to experts don't have to be in evidence. They can be facts that they considered. So I understand what the defense is saying, and we don't want a hypothetical question that 5 or 6 minutes long, and that's not going to happen. I'm going to stop that, and I don't think the state's going to ask the same question that they weren't allowed last time. So we'll just go by the rules of evidence. It's kind of like a boilerplate motion in limiting that attorneys file. Most of the boilerplate requests are rules of evidence that we all follow, And I think whatever side you're on here this morning, the attorneys are well aware of the rules of evidence and have previous trials. So we'll just leave it to what the jury instruction says on the hypothetical question. Sequestration. I don't understand what the defense is asking. I am going to order sequestration, obviously. It's something that is important. We don't want witnesses sitting here and hearing other witnesses and say, oh, man, that's what that one says. Maybe I should say something different. The only time we've had a different position is when the state comes in with their detective that did the investigation, and we allow that, and sometimes the defense has an investigator, and we allow that. Is the state asking to have any exceptions to the sequestration rule?
So, Judge, we believe we will be asking for one person to be accepted.
Was that?
So right now, we are thinking our investigator, Brian Stute.
Okay.
But just in terms, so I understand the court's ruling, certainly there's a lot of witnesses in this case, so we're going to have to, when they're waiting to testify, we're going to have
Outside.
them. Right. Just in one room, though, would that be okay?
As long as you tell them, and I tell this is the attorney's obligation, you cannot discuss the case. And if somebody tells me they are discussing the case, I have the power to say, guess what, you're not testifying.
Yes, we completely understand.
I mean, I
that,
can't sit in that room and watch them.
Right. We'll certainly direct them of that. It's just there's so many witnesses
Right.
that really they would be all over the place if they had to be in separate rooms. Some of the witnesses are married to each other, so certainly they're going to be coming to court.
And it's the same thing for the defense. You tell your witnesses, you can't talk about the case. When the case is done, you're free to say whatever you want. And it's your obligation to control your witnesses. And if I find something that's happening, we will deal with it. But I can't. This is such a small courtroom. We have so many witnesses. I think it would be very hard to police what's happening with the witnesses, except for the parties. And we will give them that responsibility. So tell your parties we are going to do the sequestration, and they cannot talk about the case. Okay, where does the defense want to go next for a motion?
We took care of that. I think there's a specific motion in limine regarding the Jensen home computer that was filed by Attorney Vishny and Renner in November 29, 2016. I think that's an easy one for us to go to.
And what's the issue on that?
I think that the motion requested that it be listed as the Jensen home computer and not Mr. Jensen's computer. I think that's the basis of the motion.
What offer of proof can the state give me that how you're going to present that issue? We know the computer's in the home, right?
Right. Correct.
So what offer of proof are you going to do?
So we're going to spend an extensive amount of time, as was done in the first trial, demonstrating when the computer was used, like time of day and dates that it was used, and the certain topics that were accessed on the computer. So, of course, the state's overall argument is going to be that this use regarding poisons and things of that nature was done by Mr. Jensen. So really, this appears to be more an argument over terminology. But the state intends to prove, based on the totality of the computer evidence, that the person making the searches for things that would be evidence of guilt was the defendant.
I think that's appropriate. And you could argue in your closing or wherever you want that it's a computer in the family home, and obviously the state's going to argue that it's Mr. Jensen that used it. But that's a fact issue, and that's for the jury. I'm not going to make a ruling that they can't say that eventually. That's a jury question. They don't believe the fact, they don't consider it. I'm not going to make a ruling on evidence today whose computer it is, because that's an issue again for the jury. Okay, let's go to something else now.
Judge, the second part of that motion, was the defense requested an order that no witness be asked about the intent of a person who deleted history, files, or specific phrases, as it would be speculative.
Is that including experts?
I think it was including experts, Judge.
Yeah, I think experts can get into that. That's why they're going to be here. They're going to say this is what happened. I mean, people are shocked when they delete something. I'm not a computer genius, but I know one thing. They can find anything once it's in a computer on your phone. everybody always thinks, it's deleted, or I've only sent it to this site, they'll never find it. These people, experts in the computer field, are well paid. They can find anything. And if it gets into his opinion, he can give his opinion what happened. Again, originally I said juries don't have to believe experts. We're not going to have a lay witness make that opinion. It's going to be an expert. So they want to get in that area. And you could cross, the old idea of cross-examination. Ask the question, how can you come up with that opinion? What facts did you use? What did you do? And that's how you cross experts. You have that opportunity. I'm not going to limit the expert as to his statement and his expertise here today. So if he wants to make that opinion and then you cross him and destroy his opinion, well, then the jury decides what facts are relevant as to what was deleted from the computer. Okay, what's next from the defense?
Judge, there are a couple of motions I think that are really along the same line. One is one filed on November 29th, 2016, amended motion and memorandum of law in support of motion to exclude improper opinion testimony, and this has to do specifically with Dr. Long.
Yeah, but I think one of your experts used evidence that's not even allowed in and is using it in their report. So I think Ms. McNeil, I think she used a very good legal terminology.
Judge, I think my concern is more about the
Can you repeat that for me? I don't want to get it wrong. What's good?
Actually, what's good for the goose is good for the gander.
I don't know what case that comes from or what statute it's from, but that's what I'm going to rule. Experts, I've had so many experts, and you don't know what they're going to say sometimes. And if they want to bring up stuff that is not allowed, we're not going to allow it. I'm not going I had so many civil cases, and I used to tell the attorney, I can't try the whole case. They wanted me to try everything, every little issue. I said, what do we need the jury for? If we're going to try the case, it's not a court trial. So if you have an issue with an expert, with their report or whatever, we'll deal with it during the trial. But your expert is using stuff that maybe not should have been used, or facts that are not allowed, evidence that shouldn't come in. So we're going to play it equally here, so I'm not going to grant your ruling.
Judge, can I be more specific about the request? It's a very specific request. It's not just all opinion. It's a specific request as it relates to the letter that has been excluded, that Dr. Long's not able to testify.
Didn't your expert use that letter?
They may have reviewed it, but there's a difference between reviewing and relying on, Judge. And this letter has specifically been excluded by every court this case has been in front of, including the appellate court, the Seventh Circuit, and back to the Wisconsin Supreme Court. In fact, it was a unanimous decision by the Wisconsin Supreme Court that this letter was not to come in as evidence, and that it wasn't harmless error to allow that letter in.
Your expert's mentioning the letter.
Whose expert's mentioning the letter?
Your expert.
If the expert was to testify that it was something that they reviewed, but not the contents of the letter, Judge. Not the contents. Experts can review
All right.
inadmissible evidence, but it's whether they can testify about the specifics of that inadmissible evidence.
Is your expert, Ms. McNeil, going to use the contents of the letter?
Your Honor, I'll be responding to this.
Go ahead,
question.
Mr.
Dr. Long was primarily on cross-examination, was asked questions about that. The state intends to ask Dr. Long about the amount of ethylene glycol in Julie Jensen's body. We were not going to be asking Dr. Long about the manner of death in this case. We're simply going to ask him about the level of ethylene glycol in the body.
So why can't they ask him that question?
They can, as long as he doesn't say that his opinion is based upon the letter that Julie Jensen wrote that her thoughts of her husband going to kill her. That's my concern, Judge. I have no concern about them asking Dr. Long about the level of ethylene glycol. That's not what's in the motion. The motion is very specific as it relates to the letter that has been excluded by all courts, except for the circuit.
Well, Your Honor, if I may respond. The state is not intending to introduce the letter at any point in his case in chief. However, it's not true that any reference to the letter is inadmissible. That's
I know it, because there's non-testimonial evidence by other witnesses that the letter can come in.
No, the non-testimonial evidence from other witnesses is that there was an existence of a letter, not the contents of the letter. I mean, there's a big difference there, Judge. The calls versus the contents of the calls.
All right, we'll stop it right here. I don't think the state is telling me they're going to use the content of the letter, and it's not going to, the content of the letter is not going to come in.
Your Honor, I'll just say this. What the Wisconsin Court of Appeals said in Jensen 2 was that one of the reasons that they thought it was harmless error for the letter to be admitted is because everything that was set forth in the letter was attested to by other witnesses. And so that's the content of the letter. Largely, most of the content of the letter was attested to by other witnesses in non-testimonial statements. So even if the letter hadn't come in, the jury would have heard, for example, about the Post-it note because Julie had testified about, or had spoken about the Post-it note to other witnesses. And references to the letter are admissible. References to the content of the letter are admissible. It's the letter itself that is not coming in the state's case in chief. Now, when
I'm going to stop you here. We're not going to decide this issue today. If the defense wants to give me a written argument within 5 days, I'll consider it. And the state wants to respond in 5 days.
Judge, are we talking very specifically about the contents
Just
of the letter?
that's all. No other issue. So I don't want to get my.
Only, Judge, the only reason that I ask is because there is a difference, and I understand that Attorney Jamboy is talking about Jensen 2, which was overruled by both the District Court, the Seventh Circuit, and the Wisconsin Court of Appeals, because they found it wasn't harmless error, and in fact, it wasn't duplicative, because there is a defense to that, and
All right, you got till November 25th at 5 p.m. The state can respond by December 2nd, 5 p.m.
And Judge, I think that's going to be
Very
inclusive.
limited issue. I don't want nothing else briefed. I got too many briefs on this case.
Judge, I was just saying that there's a motion to exclude references to testimonial statements. I think that the court is going to hold off on ruling that motion then until this, because they're the same thing. It's really about the contents of the letters being mentioned by citizen witnesses.
Why would I not allow non-testimonial statements?
I think the court would allow non-testimonial statements as long as there's a hearsay exception to those statements. That's not what I'm talking about. I'm talking about in reference to the contents of the letter.
All right, it's the same issue.
Yes.
All right.
So I would
So
ask
you're
the
on
court
this-
to hold off on ruling there until we file this.
Well, Your Honor, I will say this. I think this issue has been sufficiently briefed, but if the court wants additional briefs, we're more than happy to provide them.
Do
I
me the
will-
favor, help me out.
Yes.
I'm a senior citizen now.
There's a lot here, Judge, so I understand.
Defense counsel just made reference, however, she said, well, we've got to satisfy some hearsay exception. And the answer is no, we don't. Because what the Court of Appeals in Jensen 2 said, and by the way, Jensen 2 was not overruled on all points. They were simply overruled on the point that it was a harmless error. That's the only part of Jensen 2 that was overruled by the Federal District Court. But what the Federal District Court, what the Court of Appeals said in Jensen 2 is that the Wisconsin Supreme Court in Jensen 1 adopted a forfeiture by wrongdoing doctrine, a broad forfeiture by wrongdoing doctrine, which does not survive Giles, except with respect to non-testimonial statements. So with respect to non-testimonial statements, the forfeiture doctrine applies. And in this case, Judge Schrader, after a multi-day forfeiture hearing, determined that Mark Jensen was responsible, more than likely responsible for Julie's failure to appear, or inability to appear. So therefore, the defense does not have a hearsay objection to any of the hearsay statements, that non-testimonial hearsay statements. That was the ruling in Jensen 2, and that is the law of the case here. And then this whole notion about references to the letter in non-testimonial statements, that's also the law of the case. And the law of the case is that the references to the letter in the non-testimonial statements are admissible. The Supreme Court said that in Jensen 1. The Court of Appeals said that in Jensen 2. And there's nothing in Jensen 3 or any federal court that changes that ruling. So the references to, in non-testimonial statements, the references to the letter and the descriptions of the letter are all admissible, and that's what the appellate courts have said.
I'll make that ruling when after I get that brief.
Thank you, Judge.
All right, what motion do we have next here?
I think there's a motion to reconsider the decision denying defendants' motions to suppress the book, as Attorney Jamboy calls it.
To reconsider what?
Judge Kirkman's decision to allow in the book that was recovered
Have
from
any
our
new evidence, anything new that he didn't consider?
This is Jeremy Perry. No, there's no new evidence. I think that
Motion's denied. What's next?
There is a motion and numerous responses as it relates to specific instances of, I believe, untruthful conduct of Ed Klug.
That's
And I
the
think
other
Attorney-
acts motion that you have on Mr. Klug?
I think Attorney Renner's going to talk about that, Judge.
What can, Ms. McKeel, can you tell me what page your response is on?
Yeah, so this will be in the 87-page response, and there's two different responses, so let me get those for the court. So the state's first response is on page 44.
All right, thank you. All right, go ahead, Ms. Renner.
Your Honor, under the rules of evidence, we are always able to get into specific instances of untruthful conduct. As far as the state's argument that the district attorney who ultimately was charging Mr. Klug at the time in regards to a statement that he had not hit a casino machine when the video showed that it had, according to the criminal complaint, I believe is inapropos, just because the state decided not to charge or determined that they could not meet the burden of beyond a reasonable doubt does not preclude other acts from coming in. As far as his financial dealings, I believe most of these would go to bias and need for money and ability to potentially collect on his notoriety that comes from this case. I think the question for the court is, under the rules of evidence, are these going to be considered specific acts of untruthful conduct wherein I have to accept the answer of the witness without being able to impeach using extrinsic evidence, or whether this is going to be allowed as other acts because there is such a pattern of untruthful conduct by Mr. Klug that at this point the pattern would allow us then to impeach by extrinsic evidence.
Well, as to the financial information, there was the correct terminology is FINRA. It's got to be some sort of.
It's like Oler for stockbrokers.
It's got to be some kind of board that if you do something wrong, they investigate you. They found that there was no issues as to what the complaint was about on all the complaints. There's no police reports. There's no complaints to the IRS. There's no complaints to the SEC. You still have to prove your other acts by the preponderance of the evidence, and a lot of the issues dealt with the divorce proceeding, the issues of the financial misconduct. There's no criminal charges. One of the complaints was filed by somebody who had a bias towards Mr. Klug. It was out of a divorce case. There's depositions talking about certain financial testimony, and I don't think that goes to any untruthful statements. And but I do have an issue with this criminal charge. I mean, the financial issues. There's a divorce. There was some complaints. There was no findings. There was nothing. But the criminal charge. What information does the state have as to exactly? I want something concrete, just not a statement. Why the state dismissed the charges? Why, you know?
So our belief that we put in our response is that the ADA concluded that the video did not show Mr.
Yeah, but do you
Klug.
have something in writing that's her statement, or is that just your belief?
So that's what I have right now. The defense did respond to the state's response and indicate that they were going to look into this issue further, but I have not heard anything else.
Has the defense looked into it further for why they dismissed it?
Your Honor, unfortunately, being a defense attorney, the DAs don't feel the need to tell us why cases are dismissed. So,
Judge, I can see if this ADA has any ability to look up her file and provide something, maybe she can email or something like that. The other thing I would note about this criminal case is that it was alleged to have occurred in April of 2016. So at the time of trial, we're approaching almost 7 years later. So regardless, I would like the court to take into account the time that has passed.
I usually use 10 years. I've used that on all cases. So it's within 10.
And also to be clear, Judge, obviously this was a case that was dismissed. However, I can see if this ADA, if she's still an ADA, would be willing to respond to us and look at her file.
Yeah, I'm going to allow it unless you give me something else from the DA as to her reason for dismissing it.
and Ms. McNeil, if you are able to reach out to the DA, we would appreciate the ability to see the video if it exists.
I will see what I can get from this ADA, again, if she's still an ADA. I don't know her at all.
All right, what do we have next?
Judge, I think all that's left is standard motion and limines.
Which motion and limiting issues do we have?
Attorney Vishny, I think, filed one, and then I filed a subsequent one.
What's the issue in those motions?
And Attorney Vishny's filed August 14th of 2017. There's some information specifically about Laura Koster. We already took care of number 2, which was the victim. We already took care number 3, which is evidence about earning money from the book. I would not argue. Number 4, I believe Attorney Jamboy agrees that they won't talk about the fact that he was convicted or sentenced.
So what ruling do I have to make here?
I think number 4, Attorney Jamboy agreed, so I guess the court could grant it.
So just so we're all looking at the same document, this is from August 14th of 2017, and this is the one labeled motion in limine to preclude prejudicial evidence, admit evidence, and set forth procedural trial matters. Is that accurate?
That's the one I'm saying, yes.
So I still don't know what the issue is.
There are 9 motion in limines that Attorney Vishny filed, and then there are 6 procedural
Right.
not sure
And
that
you
that-
talked about some that both sides have agreed to already, right?
Correct.
So tell me what's,
Number 2, the court already ruled on as it relates to victim, so that has been settled.
okay,
Number 3, any evidence that Mark Jensen intended to publish or earn money from a document seized from his cell.
has that been decided?
It has not.
Is the state going to bring in that? Obviously, the books issue's coming in, but are you going to bring in that he earned money off it or he wanted to earn money?
We were planning on making some reference to his motivation in writing the book. It was to tell his story, and he expected to make a lot of money off of it. And it's the defendant's own words that we're going to be using. It's
What does that have to do with the guilt or innocence?
Well, it's the motive for writing the book, and whether, and he's indicated it's his purpose to tell his story, and that he was going to make a lot of money off this book. And money was one of the reasons the defendant murdered his wife, so he wouldn't have to pay child support, so he wouldn't have to split up his assets with her. Money is a motivating factor for Mark Jensen throughout this case, and the state is allowed to present evidence concerning motive for the crime. That's one of the reasons that the book, that the state will be requesting certain portions of the book be admitted into evidence, is because of.
Don't we tell the jury that we don't care about motive?
No, we don't tell the jury, we tell the jury that the state's not required to approve motive.
That's what you said it better than I said.
But nonetheless, motive is something that the state can prove, it can demonstrate.
I agree, they can bring it in, it goes to motive. Might not be true, but it goes to motive, so it's coming in.
Number 4, any evidence that Mr. Jensen was previously convicted and sentenced in this case. I believe Attorney Jamboy
Well,
agreed.
we're not bringing that in.
Yeah, the state does not plan to bring that in. I will say this, Your Honor, the defense did not file a motion for change of venue, and the odds of us picking a jury in Kenosha County that doesn't know that Mark Jensen was previously convicted of this crime, I just don't see how this could be possible.
Well, that's their decision.
We're just asking that they don't bring it in their case in chief.
It's not coming in.
Preclude the prosecutor from informing the jury an opening statement what the anticipated defense would be, as that would be burden shifting.
I mean, we don't think that this is burden shifting. We agree that an opening statement is a statement about what the expected evidence will be, and both parties, everyone is to avoid argument, so we agreed to abide by those rules of opening statements.
We don't give the juries an opportunity to take notes during openings and closing, and there's a jury instruction that I read that opening and closings are not factual statements, they're not to consider it. It's just, an opening is the obligation of either side to show what they're going to prove or what they're going to do. And then when we do the closing, just to go over what they think has been presented. And I think, again, the attorneys are well aware of what they have to do during the openings and closings. So we'll just abide by the rules of evidence.
So that would be granted.
Yes?
Preclude the prosecutor from vouching. I believe that Attorney Jamboy agreed.
We don't intend to vouch for witnesses.
All right.
Preclude the prosecutor from eliciting evidence of any telephone conversations by any witness unless the state can properly authenticate the voice.
Well, what we responded to this is we cited the authentication statute. There's many different ways to authenticate a phone call. It's not just the voice of the person. So we certainly will be abiding by the authentication statute.
Again, it's the rules of evidence. However they bring it in, they bring it in.
Any evidence the defendant has committed other bad acts not previously litigated before the court.
Do you have another X motion on the defendant?
So what we had indicated, and I believe this is in our motions in limine, is that Judge Schrader had allowed at the prior trial other acts of the defendant, and that those are the only other acts we intend to present again based on the prior ruling of Judge Schrader in the case.
Was that issue appealed?
I don't believe so. If it's the panorama evidence, I think that's already been, also Jensen 1, that's the rule, that's the law of the case, so.
What other acts did the state bring in the original Jensen trial?
The other acts, Your Honor, from the last trial particularly pertain to the defendant leaving photographs around the house and claiming that photographs were left on the windshield of his car. These are photographs of a female head in close proximity to an erect male penis. And the state indicated that there was evidence that Mark Jensen was doing this in order to punish his wife for an affair that she'd had in 1991 or 1992. This evidence was deemed to be admissible by Judge Schrader because it was related, it demonstrated the defendant's hatred for his wife and his motive to kill her. And that's why it was admitted. And the state had a significant quantity of evidence supporting that, including testimony from the officers who'd investigated those instances, and also a private detective that Mark Jensen himself had hired, who also came to the conclusion, all the officers and the detective, the private detective, advised Ms. Jensen that it was Mark Jensen that was doing this. And Mark Jensen, during the course of his interview with Detective Ratzberg, conceded that he had on occasion planted these photos around the house as a means by which to get back at his wife when they were having arguments. So that was the other evidence, Your Honor.
That's the law of the case. It's already been confirmed by the appellate court, or by the Supreme Court in Jensen 1. So that's not what this motion is. It says not previously litigated before the court.
Yes, and the state does not intend to present additional other evidence
That'd be granted.
beyond what's contained in the book. I mean, there are references to things he wrote in the book, but those are all statements by a party opponent. And the state is not contemplating any additional other evidence.
All right, then we got an agreement. Let's go on to the next question.
Judge, as to the stuff in the book, we haven't received notice specifically about what they're trying to put into evidence. So if it's an other act, we would need notice of that. The
just
book
said it-
was not litigated before Judge Schrader. Or
Did I hear you, or did I not? You said you're not going to use other acts from the book?
No, what I said is that there are references in the book. There are things he wrote in the book that we will be using, and we have notified the court and counsel that the state would get that to the court and counsel sometime in advance of the final pretrial in December, which is scheduled for December 16th.
We'll wait for the final pretrial to see if it's given to the defense.
so we'll hold off on number 8 then.
And just remind me.
Okay. And then the last one the court already took care of as it related to discoverable material. I think we discussed that already.
All right.
The procedural things that Attorney Vishney, we already took care of number 1. We're not going to allow jurors to ask questions. We already talked about sequestration. There's no distinction in voir dire between possible prosecution and defense witnesses in the court. Introduce witnesses if possible from the witness list.
What's the issue as to the witness list?
Is that there's no distinction between prosecution and defense witnesses and the witness.
I'm just what I normally do is I ask the state to name their witnesses, and then I just say if there's any additional witnesses the state wishes to name. I mean, the defense wishes to name.
Okay. That all proceedings be recorded, including sidebars, voir dire, opening, closings.
Well, it's up to the attorney what they want to do with their sidebars. I have trials where the lawyers run up and do a sidebar, and then we take a break and they never put it on the record. That's not my responsibility. It's the lawyer's responsibility, how they want to handle it.
So I want to know how the court wants to handle sidebars. Is
Well,
this something we're going to have?
if you had an objection and you come up and do a quick sidebar, tell me that when we go on a break, you want to put it on the record. I think that's the proper way of doing it. I don't like it when the jury has to keep going back in and out every 10 minutes. They get confused. They say, well, what are they talking about when we're not in here? So just say, I want a sidebar, come up here and tell me what you want, and then tell me I want to put it on the record when we're not having the jury.
And Judge, as to objections, does the court just want like hearsay and then we do a sidebar, or do you want speaking objections? I would ask the court to limit speaking objections, obviously, for the reason that not some of that information should always be in front of the jury.
I think objections, you do have to give me a reason, but I don't want you to start arguing in front of the jury.
Okay.
Give me what evidence I should not allow, hearsay or confrontation or whatever, but don't start arguing, because that's not what the jury should hear.
I think number 5, the court probably does, which is prior to the opening statements of counsel, the jury be instructed by the court as to the elements of the offense charged.
I do instruction 50, and I think the state gives me the elements that I have to read as to the charge in that number 50.
Thank you. And number 6 is the jury be given written instructions for use during deliberations on the instructions that are within this document, burden of proof, presumption of innocence, elements of the offense, and any other instructions deemed by the defense after close of evidence to be germane to the issue. And I think we could probably do that during a jury conference.
We can do that during jury instructions.
Judge, I don't think my motion in limine that I filed are anything more or less than that, honestly. I filed mine because we had a deadline and I wanted to make sure it was filed, and honestly, I hadn't gotten through everything yet. So I think the court probably ruled on all of these. The only one we have to talk about, we already talked about the book. We talked about criminal convictions. The court's fine with doing that prior to the witness testifying.
Right.
We are going to talk about the letter. I think that's in my motion in limine and the voicemail, so I think that's the motion that the court asks us to file by Friday.
I will give you a ruling then when we come back at the pretrial on the 16th.
Okay? And then there's pretty just standard. I think Attorney Jamboy agreed. I mean, they're just standard instructions like state be precluded from introducing any evidence or medical records which haven't been provided. Oh, Judge, I'm sorry. As it relates to the one that Attorney Vishny filed, there is one specifically as it relates to Laura Koster. There's a number of different, there's A through F to exclude evidence as it relates to Laura Koster being a witness for the prosecution of her father from 1989. It has no probative value, and we're asking the court to exclude it. The Judge Schroeder did not permit the state to cross on this issue, and we would ask the court to rule
Is the
the
state
same.
going to do that or no?
Well, since Judge Schrader ruled we couldn't, we're not challenging
Okay.
that ruling from
All
Judge
right,
Schrader.
we answered that question.
Thank you. So these all look like they were things that were not allowed. Number in B, Judge Schrader did not allow the prosecutor to ask this question at the forfeiture by wrongdoing hearing. Does that mean the same?
Right, the state's response that was filed indicated we were not challenging Judge Schrader's prior ruling.
Thank you.
So are there any in A through F that the prosecution disagrees with?
Yes, so the next one is C, and that one involves questioning of Laura Koster about the possibility that she withheld some information when answering questions at the forfeiture hearing. And the state just thinks it's generally true if a witness has previously testified and then in their subsequent testimony it appears that they withheld information the first time, that the state should be allowed to inquire into that.
So she testified at the forfeiture hearing?
That's right, and apparently during the trial there was the implication that she had withheld information, and so the state, I think this is kind of a general principle that if the state believes, based on a prior transcript, that someone has withheld information, that the state should be able to inquire into that.
I think if it's an inconsistent statement, but if she wasn't asked, she couldn't have answered it. And I think there's a distinction there.
Sounds like a great cross-examination question.
I would just ask the court not to allow testimony that was
I'm not going to
asked.
try the whole case.
Okay.
It's not a court trial. You want to waive jury?
No.
Okay.
I think this is a hypothetical question that was asked to a citizen witness under D, and I would ask the court to exclude it.
Did we ask a hypothetical to a lay witness?
Yes, we believe that hypotheticals are allowed for lay witnesses, and we cited 907.01 for that.
What was the question? Do you remember what it was?
I think it was about,
Questioning Laura Koster that a good parent who saw the other parent barely able to breathe would call the ambulance.
Well, if it's in proper form, they'll be allowed. Again, I'm not going to pre-try the case.
E is questioning Laura Koster about whether she was ever coached by the prior defense attorney to not testify about certain things at the forfeiture hearing. I think that would make Attorney Elby potentially a witness. I don't know how it's relevant as it relates to the. I don't think
You
it's
got a
relevant
comment?
to
So I think this is related to the one we just talked about, where if it appears that a witness was withholding information, the state should be able to inquire into that.
We will wait to see what the witness says on the stand.
Questioning Laura Coster if she had known that Mark was having an extramarital affair at the time Julie told Ms. Coster she was afraid that he would kill her, and whether Ms. Coster would give different advice because she allegedly knew that Mark had a motive to kill. I think that's a hypothetical, and I think the court's already ruled that we'll have to wait to see.
We'll wait and
more of the
see.
question. Okay. I think I've gotten them all now, right? I don't know if there's any others that, I think the rest of the motion on limines that I filed in November of 21 were agreed to. They're pretty standard, not allow vouching, prohibited from shifting of burden.
We got anything else we need to address from the state, Ms. McNeil?
So we do have the state's motion that was
Well,
filed.
first of all, Your Honor, we have not addressed all the defense motions. I would commend the court's attention to the state's consolidated responses to all undecided defense motions. We filed that June 27th. As you indicated previously, I think it's like an 87-page document, but the actual response is less than that. That included attachments. But on page 16 of that,
Let me get there first.
I guess that actually was the state's response to defense response.
What issue are you talking about now?
Talking about the testimony that defense counsel seeks to elicit from Dr. Christopher Long about the Patricia Stallings case.
And I think Judge Schrader ruled there was no factual basis for that testimony to come in.
Yes. What happened, Your Honor, at the first trial is that defense counsel proceeded to bring in the Patricia Stallings case without having filed another acts evidence motion in advance of trial. This necessitated the court taking a break in the middle of the trial, allowing the defense attorney to voir dire Dr. Christopher Long outside the presence of the jury. And after this extensive voir dire, Judge Schrader specifically ruled that all of this was inadmissible.
Was there another acts motion filed about the defense to bring in this Stallings case?
I think Judge Schrader ruled that the information about the Stallings case as it related to a woman being put in prison and this mistake that was made was not allowed. But
I think I got this exact wording. It says the answer is no.
Yep.
For a variety of reasons, beginning with the fact you didn't even establish that he committed a mistake, made a mistake. No, I'm not going to argue about it. I made my ruling. I think the record's full. So,
But the judge did allow Attorney Elby to cross-examine Dr. Long about the whiting out of information on an exhibit that was presented to the jury, and the defense would like to do that again.
about you're talking about the Stallings case?
In the Stallings case, when Dr. Long testified, he whited out information on an exhibit at the request of the prosecutor, and Judge Schrader allowed that, but did not allow the other information about the Stallings case to come in.
Well, I wasn't at the first trial, so.
Your Honor, first of all, if defense counsel wants to admit other acts evidence of Dr. Christopher Long in this new trial, they're obligated to bring another acts evidence motion, and they've not done that. The state is, I'm not aware of, I do have this vague recollection about this thing about an exhibit, but I believe the defense counsel is required to bring another acts evidence motion if they want to introduce that into evidence in this trial. And the state.
Let me just stop you here. Where's the other acts motion then that you were arguing?
Judge, I'm not arguing another X motion. This was, the prosecutor filed a motion to exclude it, and there was a response by the defense as why it should be included. It was filed by Attorney Vishny on July 12th of 2017.
Let's give the state a chance to look at that.
Well, Your Honor, the state is opposed to allowing this cross-examination of Dr. Long on this issue, but I would need to go back and review the transcript of the trial on this specific issue. Could the state file a written response on that issue? When we responded to this, we were responding to the issue of cross-examining him about the Patricia Stallings case generally, and Judge Schrader excluded that. But I don't have, as I'm sitting here, I don't have a specific recollection of the cross-examination or the discussion on the record of this marking of an exhibit. And so I would request that I be allowed to file a written response.
Yeah, well, we could deal with it at the pretrial. Just remind me.
Thank you.
Okay, what motion does the state have that we have not decided? Didn't you say something, Ms. McNeil?
Yes, so that was filed on March 28th of 2022.
Okay, hang on here.
Is that just refiling
Is
of
that the
the
unavailable witnesses?
Right, it starts with 2 issues, and then it repeats what the state had filed for motions in limine. So the first issue that the state presented was just repeating what we wished the court to decide, which was the motions in limine, which are attached. The second issue is about witnesses becoming unavailable, and we filed last week, and the defense would have received our amended witness list that indicates who we believe is unavailable, either due to death or due to some health issues. And so I guess I would inquire of the defense if they had any objections to the people that the state designated as unavailable.
We got a response?
Judge, the witnesses that are deceased, we have no objection to them being unavailable. There's only one witness that I'm aware of that is not deceased, Ted Wote, and he is receiving medical, Wote, W-O-J-T, I believe. And he is receiving medical treatment for a cancer diagnosis. I guess I'm unsure from the letter from the physician that he's unable to testify or that he thinks it would be difficult for him to testify.
Do we have a letter from the state, from the doctor?
There is.
Yes, we submitted that to the defense counsel last week, and we can provide that to the court as well.
Why don't you provide me that letter? All right, what other state issue that I have to decide?
So there's one other person who the state indicated was unavailable, and that's Joan Scully. And she, I believe, has some form of dementia, so we don't believe she's capable of testifying. She did testify at the prior trial, so we indicated we would like to use her testimony, even though she's not deceased.
All right, what's the defense position as to that?
I think if there is a diagnosis of dementia, that would be make a witness unavailable. We also have a witness that we believe has a diagnosis of dementia, but we're waiting to get medical confirmation from her doctor.
Give me some kind of confirmation. That's for both sides.
Yes.
And again, if the defense wishes to present to us a stipulation or agreement, that's likely something we could agree
Right.
upon.
Sounds like an even trade.
Judge, how are we going to, I think that's a good question about how are we going to present this evidence to the jury? Is this going to be a reading of the transcript? Is this going
It's
to
up
be?
to the lawyers.
Okay.
I'm not trying the case.
And I think that if it is the video or the recording, there is going to have to be potentially some editing because of the exclusion of evidence at this point.
We would agree that there may be some portions of recorded testimony that would need to be revised or excluded, and the state's prepared to do that. What I'd propose is this, that the parties between ourselves look at the transcripts of the testimony of the witnesses that we intend to present who are no longer available, and then we'll indicate what portions of that examination we deem to be inadmissible or we object to. the parties should be able to exchange that, and if we come to an agreement, then the court won't need to be bothered with it. We'll only address to the court the issues that we can't agree to.
Sounds
That's
good.
very good advice. That's what we did in the civil trials when we had testimony from doctors. The lawyers worked it out, and they agreed to what was not going to be read to the jury. And 99 out of 100 cases, they did agree to it. Okay, what do we got next, Ms. McNeil?
So our final portion of that was just, we intend to notify the parties about the use of the defendant's book by the final pretrial date in December.
And which portions of the interview transcript?
You're going to provide that information to the defense by the pretrial date, correct?
Yes, Your Honor.
And actually, regarding the interview transcript, we did file what we intended to use, and that was in, let me get the date on that.
And you're going to provide that too to the defense?
We've already provided it to them.
Already provided it, all right.
So there's a lot to dig through so that the defense knows what I'm referring to. It was on March 31st of 2017 that we filed that.
So it's the same, it's not changing from then.
That has not changed, and so I think we just need to confirm that we still feel the same about what should be used.
All right, what's next from the state?
So then, Judge, it's just following is the motions by the state. That's part of the same filing. We have the first 8 motions have to do with testimony that apparently was at least attempted to be elicited at the last trial regarding mental health history and some, I would say, other act type situation regarding Julie Jensen. And so the state has specifically moved to exclude this evidence from this trial, given that it was brought up at the prior trial. And so if the court wants me to go through one by one, I can do that, however the court would prefer.
Has the defense responded to that?
Judge, most of this stuff was allowed in at the first trial.
All right.
So I can tell the court which ones I don't
I
have an
thought
objection.
we said Judge Schrader made the correct
We
rulings.
did say that, Judge.
All right.
Well, Judge, we are bringing this up because we do not think that these particular things that were questioned at the last trial were admissible as relevant. And, you know, part of the issue is a lot of this happened during cross-examination. And so it was things that the state couldn't anticipate and couldn't file a motion in limine about because we didn't know it was going to happen.
I'm not going to make any prior rulings. If it's relevant, it's relevant. If it's not relevant, it's not coming in.
And Judge, I can tell the court which ones we would not attempt to do so that at least.
Would
the
that help the
prosecutor
state?
knows.
It would, thank you.
All right, why don't you do that?
Number 2,
Okay.
we agree.
And if somebody can just put it in writing for me, then I have it as part of the record.
Number 4, we agree. Number 6, there's no basis for us to do that. So those are the ones we would agree to without needing further argument. I think they were attempted at cross-examination, but there was no basis, and we would not attempt to do it again.
So then I guess this motion by the state just puts everyone on notice to what the state would intend to object to when it comes up at trial.
All right.
And just so the court's clear, Attorney Vishney did respond to these motions.
All right,
so
well,
there's a response.
You got an agreement of what's coming in, and again, if it's relevant, it's coming in. Anything else from the state? I do have one issue, if the parties want, I don't know if it's going to be an issue. And Mr. Jambo, you could probably respond. Was there an issue as to the termination of Dr. Maureen Levin?
Yes, Your Honor. The defense had sought to cross-examine Dr. Mary Mainland about Dr. Levin's termination of employment. Of course, Dr. Mainland was not here at the time that Dr. Levin was terminated. The state believes that any testimony any information regarding Dr. Levin's termination from employment is not relevant to this case. Dr. Levin was the medical examiner for Kenosha County at the time this case was, on December 3rd, 1998, the date that Julie was killed. But she testified at the preliminary hearing. But while preparing this case for trial, she refused to answer questions in my office about whether or not she was board certified. We knew she was not board certified. We were simply asking her questions about this, and she said she wasn't going to answer it. And I said, well, you understand that when you go into a courtroom, if you refuse to answer questions that are put to you in defiance of the judge's order, you might leave in that courtroom in handcuffs, and you are required to answer questions in court. And furthermore, when you're sitting in the district attorney's office and he's asking you questions, you are obligated to answer those questions as well. And if you don't, you're going to be terminated. And she refused to answer questions about her board certification. And as a consequence, she was terminated. It had nothing to do with her opinions concerning any of the evidence in this case. It had nothing to do with her theory of her prior testimony as to the cause or manner of death in this case. It was simply because she had not become board certified and she refused to answer that question.
So she never testified in Jensen 1, right?
No, she did not testify in the
And
trial.
Dr. Mary Mainland testified?
Yes, Your Honor.
And she was obviously the medical examiner for Kenosha County at the time, or from another county?
She was our medical examiner at the time of the Jensen trial.
So what would she know about the termination of Dr. Levin?
Well, as she indicated, she really didn't know that much about it. And she had heard things about it, but she wasn't here at the time that Dr. Levin had been terminated. I think what the defense counsel was trying to elicit from Dr. Mainland was that she was intimidated into rendering these opinions by the district attorney because the district attorney...
And that was you?
Yes, because the district attorney had gotten the previous medical examiner terminated. But she was not terminated because she refused to agree with the prosecutor's theory of the case. In fact, the prosecutor's theory of the case has always come from the medical examiners. It's not the other way around. But she was terminated because she refused to answer questions pertaining to whether or not she was board certified. It has nothing to do with the development of the evidence in this case. So it's completely...
Did we ever find out if she was certified or not?
She was not board certified. That's why she refused to answer the questions.
So, Judge, I think the concern is that as it relates to the cross-examination of Dr. Mainland testified that she was aware of some of this information, maybe not everything that Attorney Jamboy said, because she wouldn't have had that information unless Attorney Jamboy told her that information. But she was aware that there was an issue as it related to the Jensen case and her findings that caused Dr. Mainland was aware that there were issues with Dr. Levin and her findings in the Jensen case, or her testimony in the Jensen case, that caused her to be terminated from her employment.
Did she
knows
testify
nothing
to
about
that
her
in front of
findings.
Judge Schrader?
She testified that she was aware that Dr. Levin was terminated.
While you're looking at those other transcripts, see what she said in Jensen.
So, Your Honor, I can tell you this. The whole theory of the cross-examination of Dr. Mainland was to suggest, plant in the jury's mind, that Dr. Mainland was somehow intimidated by the prosecutor into rendering the opinions that she rendered in this case. Contrary to what defense counsel just said, there was nothing about Dr. Levin's testimony.
That's what I'm saying. Get the transcript and let me take a look at it.
Okay.
So remind me, that's another issue for the pretrial. All right. I'll ask the state, we got anything left?
So I think there's one other point in our motion in limine. So this would be about this letter for Dr. Long.
Oh, yes. The state had filed a motion to prohibit the defendant from introducing evidence concerning, in fact, introducing the letter that I had written on June 18th, 2003, and sent to defense attorney Craig Albee. The state objected to it as it being irrelevant, hearsay. And the defense sought to introduce the letter under a variety of theories, and the state will then address that. And we did so on, what was the page of this document? The document is document number 1487, and was filed March 28, 2022.
Get to that document 1487.
Yes, Your Honor.
For the record, right now, there's 1,515 documents.
And Judge, this is something that was specifically ruled on by Judge Schrader. And what he said is he was going to allow the letter to come in through the expert. Otherwise, basically, Attorney Jamboy would be a witness in the case because it's a prior inconsistent statement.
And Your Honor,
What expert are we talking about?
Dr. Long.
well, how would Dr. Long be in a position to testify about a letter that the prosecutor wrote to Craig Elby? There's no foundation for Dr. Long to be testifying about that letter.
Let me just stop you. Did he use the letter at any time to form any opinion?
Dr. Long?
Yes.
He never saw the letter, Your Honor.
The letter was a specific statement by Attorney Jamboy as to what Dr. Long was going to testify to at the trial.
Okay.
Dr. Long did not testify consistent with that letter, making the letter from Attorney Jamboy to Attorney Elby an inconsistent statement of a party opponent. This was argued at great length before Judge Schrader, and Judge Schrader ruled that it was an inconsistent statement and the letter could be used, and he basically said that he was going to allow the letter in so that Attorney Jamboy himself would not be a witness, because otherwise Attorney Jamboy would have to testify as to the prior inconsistent statement, which would make him a witness in the case. So instead of making Attorney Jamboy a witness, Judge Schrader allowed the letter in as cross-examination of Dr. Long.
And the state opposed that at the time, Your Honor, and none of the criteria that apply to the admission of prior statements by prosecutors, none of those criteria were met in that case. But
Attorney Jamboy conceded that some of those were met.
well, I concede, Your Honor, that I wrote the letter and that the letter was in error, that I wrote that letter, that I committed an error when I wrote that letter. Then let me finish, counsel. Then at the time of the forfeiture hearing, Dr. Long did not testify in a manner which was consistent with the content of my letter. At the time of the trial, he did not testify in a manner which was consistent with that letter. So the fact that the prosecutor made a mistake in, March of 2003, I'm sorry, June of 2003, is not relevant, was not relevant at the time of this trial in January and February of 2008, and it's even less relevant now. So the error that I'd made in that letter was based upon a letter that Dr. Long had written, and that the state agrees that Dr. Long's letter is admissible. Dr. Long's letter made reference to the content, the amount of ethylene glycol in Julie's blood and Julie's stomach, and he described the ethylene glycol in her stomach as a large amount when it turns out it's a half a teaspoon of ethylene glycol in her stomach. That was discovered when the defense attorney filed their expert witness report, Dr. Rumach's report. So this was all resolved months, years in fact, in advance of the 2008 trial. And allowing Dr. Long to testify about this letter that I wrote in 2003 does not address the issue of it makes me a witness in the case. And I don't wish to be a witness in this case because I'm prosecuting the case along with Deputy District Attorney McNeil. So I don't think that this letter is admissible, and it doesn't fit any of the criteria for admission. It is a statement by the prosecutor, but it was never made in a courtroom. It was never made in an opening statement. It was never made in a closing argument. It was made in a letter to a defense attorney months in advance, in fact, years in advance of the case going to trial. It's just not relevant. It has nothing to do with the facts of this case today.
I'll give you a brief response from the public defender.
So, Judge, specifically the three things that the Judge Schrader considered were the law in State v. Cardenas-Hernandez, Cardenas-Hernandez, 219 Wisconsin 2nd 516. Judge Schrader found that it was an inconsistent statement because it went from a very large quantity of almost pure ethylene glycol in the stomach, which is what Attorney Jamboy wrote in his letter as an agent of the state, to just a large amount of ethylene glycol. So there is a difference between pure amount of ethylene glycol in the stomach to 660 milliliters to a half a teaspoon, which is what Dr. Long later testifies to. So Attorney Jamboy agreed that it was an inconsistent statement in his arguments before the court, and Judge Schrader found it was an inconsistent statement. It's equivalent testimony of something that of a defendant or a witness, Judge Schrader found it holds true that it seems to me that Mr. Elby has the right to argue to the jury that there's a circumstantial case tending to show that Dr. Long gave some faulty information which would tend to raise doubts about the accuracy of some of the reports in this case. That was number 2. Third, the trial court must, in a hearing outside the presence of a jury, determine by a preponderance of the evidence that the inference the prosecution seeks to draw, in this case, the defense seeks to draw from the inconsistency, is a fair one, and that an innocent explanation does not exist. Judge Schrader stated, "It strikes me that this isn't a question of an innocent explanation or anything. This is a suggestion that there exists various circumstances consisting of your letter and Dr. Levin's testimony," because Dr. Levin also relied upon this information from Dr. Long. "At preliminary examination, there are circumstances which might suggest to the jury, and I'm not saying that I conclude this or I believe this, but the defense would be entitled to argue to the jury that the circumstances suggest that perhaps Dr. Long was a little careless in things that were stated to the people, and that strikes me that that would meet all 3 tests." Judge Schrader further found that crossing Dr. Long on the letter, literally it is a substitute for calling Mr. Jamboy as a witness, which you can't realistically do in this case, and so I won't even comment on the 3rd. So my ruling is the letter could be presented as a statement against interest by the government.
Did the letter then come into evidence, and was it used when the defense cross-examined Dr. Long?
Yes.
All right. Give me the transcript portion again, and I'll make a ruling at the pretrial.
It was filed January 10th, 2012, page 284. I'm sorry, it's document 27-4. I've got some different pages in here, sorry, Judge.
When was it filed?
Oh, that's why that's long thing down there. Okay. It's the January 16th, 08, page 289, 276 to 289. It was Dr. Long's testimony transcript, January 16th, 2008. Oh, man, I do. Hold on one second, Judge. There's too many documents. I thought Attorney Vishney had it in hers. Transcript 216, it's the January 16th, 2008, transcript 216. You're asking for the number on the exhibit list?
Yes.
I know it was attached as an exhibit to her response. Maybe document 27-3, Judge?
Want to give me the number again?
Oh, maybe not. I'm going to have to, I have a number of different transcripts because some were attached to the appellate briefs. This is from his testimony, though. I don't know, this goes to 145, but I think it's the same. From the transcript, 27-3. I don't know what e-file number it is, Judge.
All right, why don't you just,
Find it.
if you can contact the court and make sure the DA is part of that,
Absolutely.
so there's no ex parte communication.
Your Honor, why don't I do this? Well, we will pull up the 2 exhibits. One is Dr. Long's letter, and which the state agrees that Dr. Long can be cross-examined or examined in direct cross-examined about the letter that he wrote. And then we'll pull up my letter that, and we'll mark that as an exhibit that we produce, that we provide to the court. The state's response is that my letter of June of 2003 was based upon my misunderstanding arising from Dr. Long's letter. So the state agrees that Dr. Long can be cross-examined about the letter that he wrote to the state concerning the circumstances surrounding Julie Jensen's death. And in that letter, he indicated that there was a large, I think he said a large amount or a large concentration of ethylene glycol in the stomach. It was something like 3,200 micrograms per deciliter, maybe 3,280 micrograms per deciliter in her stomach. The state agrees that Dr. Long can be cross-examined about his letter. The state objects to Dr. Long being cross-examined about my letter to defense counsel because Dr. Long never saw that letter. He had nothing to do with writing that letter. That letter was my letter, and I don't wish to be a witness in this case, and I don't think that the kind of what Judge Schrader did at that time reflects the correct application of the law to the facts. Now, the state had not known that defense counsel was going to be seeking to admit my letter into evidence until defense counsel started cross-examining Dr. Long about it. So this objection and the court discussion all occurred kind of, you know how things come up in a courtroom. And there was not the opportunity for the trial court to address this in advance of trial. Well, now you will be given that chance. So I would commend to the court's attention the letter that was written by Dr. Long, my letter that was then written to.
Just provide that to me prior to the pretrial.
And I wish to emphasize,
both letters.
And I wish to emphasize, Your Honor, that Dr. Long testified extensively about his letter, and I was cross-examined extensively about his letter, and the state has no objection to that. I just object to my letter coming into evidence.
Give me both letters. You give me the transcript. I'll make a decision.
And Judge, just to be clear, like the letter that Dr. Long wrote, there's no question about that. That's his letter. But what the argument was, and Judge Schrader took the time to listen to this, is a statement of a party opponent. So if we can't cross-examine Dr. Long on the letter itself, we have to bring in the witness who took the inconsistent statement, and that's Attorney Jamboy.
All right. Give me the transcript portion. All right. What do we have left? Hopefully the answer's nothing. We got a no from the state?
That's correct.
We got a no from the defense?
Judge, I believe, except for the outstanding issues, we've covered everything.
All right, remember, we need a written order for everything that was decided today. I've given you briefing times. I want the transcripts and the letters to make the decision. We do have a final pretrial. I believe it is December 16th. We do have a speedy trial now that's been filed. We are within the time frames for that speedy trial, for the record. Anything else from the state before we adjourn?
We'll just put on the record the state's requesting a transcript of this hearing because we want to make sure that the order reflects the court's ruling, so we'd request a transcript. We'll prepare the order shortly after we get the transcript.
Anything else from the defense?
Judge, how long did we put aside for the final pretrial?
That's a good question. Let me open up my calendar here. We guys got 45 minutes on the calendar. We can go longer if we
We're going
need.
to need much longer than that, Your Honor. Considering the number of issues that are going to be addressed, I mean, even the issues, just the transcripts of the testimony.
Choose your words carefully.
We'll try to, the parties will try to resolve those issues among ourselves, but I anticipate there are going to be some areas where we disagree.
We'll give you as much time as needed.
Is that at 8:30, Judge?
Yeah, 8:30.
Okay. That's what I have on my calendar. I just want to make
Yeah.
sure that that's correct.
All right. We're in recess. Thank you.
Thank you,
Have a
Judge.
good day.
You too.
What happened to our other case? Did they leave? Other case left? All right.
They wanted more time.
We need a little break, tell them, we'll take them.
It'll be in the morning time.
Okay, I guess it won't take all day, so we'll have a feeling for this afternoon. I'll see something.
Okay, but if
Are
one for you to see. Thanks. Thank you.
Got it.
Start at 1:30. See you then. 10:14. But then when I put aside for the, they don't use it. So you don't know. You don't. It's hard to schedule. You're gonna find that out a lot.
There, all right.
Thank you, Mackenzie. Good to see you. Oh, look at these zeros. I must have hit the keyboard.
I mean, it depends on the witness, but like, you know, we don't intend to.
My dog decided to chew up a toy this morning and left little pieces of fluff all over my house, and I keep finding them randomly on my suit coat.
Little presents.
Exactly. That's what I get for getting a puppy.
What kind of puppy did
Got
you
a
get?
newfie that sheds every day, so.
Oh, yeah.
We
our-
vacuum in the morning and afternoon, no difference.
Exactly. We got a border collie puppy,
Oh, yeah?
and he's just the sweetest.
Is it a male or a female?
A boy.
Boy.
But he is just the sweetest little boy. But my God, the clumps of hair.
What did you
Doesn't matter
get?
how many days.
It goes in cycles. I think during the winter they get more hair because of the weather, and then
Yeah. But yeah, his name is Socks. He's a border collie.
Aw, cute.
He's very much my daughter's dog.
How big does he get?
What's that?
How big does he get?
Just like that big,
Too big, huh?
full grown.
Right size? Good size.
Yeah. He's like, I think he's considered a medium-sized dog.
Okay.
He's taller than my pit bull, but much skinnier.
Okay.
So,
Just send it to all three of us. Yeah, that's just easier.
sounds good. I did. I actually already started the order, so, for a hearing.
I need stuff off my printer. Left?
I don't know if they left, but there's else in the building.
All right.
I was gonna check with Jan to see if she.
You gonna be able to get the transcripts before the 16th? So you can, okay. Well, I didn't put much in there because I didn't know what the heck motions you were talking about, so. Okay, so I'm just putting motions discussed and,
Attorneys will file an order as to what decisions were made by the court. And
Okay.
then the ones that were not made, we're gonna decide on the end of the
okay. Did your,
Gardner send you?
yeah, we rescheduled the 9 o'clock.
Oh, you did?
Yeah,
Okay.
yeah. Thank you.
She did? Good job.
Well, no one asked me. I was trying to say something, but
Jerry, what did you do wrong? You put this on Jan's area, that little table that she's